The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better place to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether you need or want to contact a lawyer. Perhaps you'll decide that you can handle some issues yourself. If you do need outside professional counsel, you'll be better prepared, and as a result, so will the professional you select. Our goal, as always, is to help you save time, money, and achieve the best possible results. We continue to welcome and thank Attorney David Bazar from the Bazar Law Firm an associates law firm in East Providence, who gives insights and facts and figures on each session. So we want to welcome and thank them, of course. Today we're going to be talking about affirmative action, and particularly college admissions. It's been in the news, and it certainly affects many people. Courts have been wavering on it for the years. The future of affirmative action is uncertain, and just about everyone seems to have a dog in the fight at some point. Supporters say that affirmative action matters because it ensures some racial and gender diversity, and then those who are the critics say that it sort of causes reverse discrimination. Lots of heated debate on it. So, David, we've come a long way, in a way, since the days of civil rights in 1964, and they said it's illegal to discriminate. Talk about where we are right now. We know that Harvard's just had an issue about Asian Americans, and we should focus on them. But this has been going on for quite some time.
Sure, and the history of affirmative action, as you said, goes back quite a ways. And the whole idea was that originally there were groups of people who had been left behind, and it was an opportunity to make sure that they had the same access to good schools and opportunities as everyone else. And so cases started to wend their way through the Supreme Court. And the Supreme Court has held that if you do it correctly, affirmative action programs can be constitutional and they aren't discriminatory against other people. And so you might remember there was a case that was brought in California, B-A-K-E, Bakke, I guess you would say, yes, versus the California case, which was a reverse discrimination claim. And when that case was brought, the court said that in his case, they did find that there were some problems. He was denied entry to medical school even though he was otherwise qualified. But they said in general, the purpose of having affirmative action is still a good thing to have and reasonable as long as it passes strict scrutiny, which is a test to determine constitutionality. And if it's done in the correct way to promote diversity amongst the students so that you have your best educational environment, then it can still be applied.
So you touched on it briefly, and we should go into this more deeply, but it is a Supreme Court issue. But it's also been an issue that starts, if you're in California, it starts in California, and then it's going, what is the process of it starting at the state level and then getting booted around back and forth, and there is a litany of where it's gone and where it's gone back to appeals. So how does this actually take place, David?
Most times the case is brought in the state, as you say, where the college is and the case arises, but usually it's brought in the state's federal court because it's really a constitutional issue. And so the case would be first heard in the district where the federal court sits for that college or university, and then after that it would get appealed to the Circuit Court of Appeals, and from there to the Supreme Court.
And it's decided, undecided, overturned, and then eventually heading to the Supreme Court. Even as we understand it now, the Supreme Court has tried a number of these cases. I can't remember all of them. I mean, you mentioned one, Gratz
versus Michigan.
Yeah. Do you remember some of these?
And Gruner versus Michigan. So those are actually two very important cases in the history of affirmative action. One of them was brought against the University of Michigan undergrad. The other one was against the University of Michigan Law School. And in the undergrad case, they assigned points. So you got a certain number of points for ethnicity and a certain number of points for other things, such as maybe scores on exams and grades and so forth and so on. And in that case, the Supreme Court found that their policy did not pass strict scrutiny. It did not pass the constitutionality of being discriminatory, because it was a strictly almost like quota system, which they do not allow, and it was not done with any overarching view of the whole class and how you're going to put a class together and that type of thing. So that one was struck down as a policy that violated the Constitution. The law school case was found to pass strict scrutiny and pass the examination that the court did as to whether or not it was constitutional, because they didn't have a strict number assigned or whatever, but rather took the ethnicity, the racial issue, as one factor of many. And so it wasn't a determinative factor, it wasn't given a point system or a value, it was just looked at as one factor of many, with the overarching goal of enrolling a class that had diversity in it, because it's also a component of a good education to have different points of view, different people with different backgrounds, to be able to bring a discussion forward in a classroom and each teach each other, which is why these things have passed constitutional scrutiny in the past.
So it makes sense. If you have a number, a quota, that's a hard, quantifiable issue. But doesn't it make sense that you could still have discrimination in so many other ways, because it's hard to prove racial discrimination unless they literally had numbers in each column that they would check off. So you can get around whatever they want to say is discriminatory, especially when you're hearing now it's reverse discrimination.
So as you know, these things come at different times in our society. And there was a case not too long ago where everyone thought, many people thought, not everyone, many people thought that the Supreme Court might say we've reached the end of the need for affirmative action. And that's been hinted at in some other decisions where it was accepted as constitutional, but said, you know, that's today, maybe down the road, it might not necessarily be something we would approve or think is still necessary. But a case came along, and I think it was a Texas case. I'm not 100% sure.
Fisher?
It might be. And so what happened in that case is the Supreme Court actually sent it back to the lower court and said, here's what we think, you guys figure it out, so to speak. And they didn't make a decision wherein it could have been the time where they might have said, all right, enough is enough, we don't need this anymore. And maybe they weren't going to make that decision, because maybe we still do, but they didn't. So that's why this Harvard case has taken on some interest amongst people who do want to see affirmative action end, and so they all are trying to weigh in and push that agenda on that case.
Let's get into that a bit more, but in all of these cases, there comes a point where the 14th Amendment gets proffered, and it's been involved with the Michigan case as equal protection. That's what the 14th Amendment's
due
about.
rights, equal protection.
So explain how that fits into these cases.
So the 14th Amendment applies the right to due process and equal protection under the law to the states. And what happens is these cases are generally, as you probably have seen from some of the names of the cases, public institutions. And you can't discriminate if you're a public institution, so everyone is entitled to due process and equal protection under the law based on the 14th Amendment. So these cases are generally brought as constitutional violations of the 14th Amendment. And that applies to also private universities that accept public funding.
Federal funding,
Federal funds.
Public money. So when it came to the story about the Asian American students, as the story goes, looks like Harvard is guilty of racial bias against Asian Americans. Do you want to talk about that story? So they say.
And again, I haven't seen all of the facts or what is, I see what's being alleged, but I don't see the other side of the story as to what Harvard says they're doing and why they're doing it. And it's a very interesting issue because, again, it's the reverse. And there are many people who are Asian Americans who are upset about this case because they don't want to be used, and there are some groups that are trying to use this to strike down affirmative action. So they're saying what happens is a penalty, so to speak, to us, rather than it being an ability to help another group. And so those who don't want it to be used as an affirmative action, so to speak, kind of case, or to be the case to try to knock it down, are saying, we're not arguing that there aren't certain groups historically who would benefit from affirmative action and it's still needed. So don't hijack our claims and turn it into an affirmative action case.
And it could be a minority against a minority. You could be looking at it yet another way.
Right, and so it's not dissimilar to what Bakke brought way back when, and it does impact, as you say. If it hurts one to help the other, is that going to take away the help for the other if you say, well, you can't hurt the one? So it is a very difficult conundrum that the court will eventually have to weigh in on.
So when you mentioned earlier numbers and quotas not being constitutional, not being legal, in this Harvard case, they were talking about not the numbers such as what your SATs were or what your achievement scores or grade point average might be, but rather they had another set of scores that were based on personality. And for some strange reason, a group of Asian American kids seemed to score especially low on personality. I don't know how they developed that scale, but anyway, they yielded a lower number and therefore were accused of bringing the numbers down and discriminating against them. In terms of constitutionality, being able to say, I don't like you, you're not a nice person, or you don't play well in the schoolyard, even though you have great grades and grade point average, certainly it makes sense that they wouldn't want to rely on that as being a great rule of thumb, even though it gets factored in.
Right. So historically, what we talked about already is where you use race as the factor or a point system rather than one of many factors, that's unconstitutional. Where it's one of many factors and the overarching goal is to enroll as diverse a class as you can, then it's been accepted in the past. So the question is, what kind of standards can Harvard, in this case, use to determine how they're going to best be able to enroll a class that reflects a diverse culture? And so I think from the Asian American perspective, or the Asian perspective of all their students, where there are so many applying with so many of the other qualities that are factors of perfect SATs, 4.0 GPAs or higher if you can, and those kind of things. Well, how do you differentiate amongst that group? And if you differentiate amongst that group, are you then reverse discriminating because you're going to accept a group of scores from other groups that are lower than those, and how do you justify that? And it really goes back to having a plan or a program in place that does it in an overarching way from a 10,000-foot ceiling or point of view, so to speak, that looks at when we're trying to enroll a diverse class, and this is the method that we're using to do that, and it doesn't discriminate against one group or another in the sense that we're only looking at one of many factors.
So in the case of the Asian Americans, high IQ, high GPA, high scores, they want to Harvard's an elite school. These are among many selective schools where this issue is brought up. But not all college students are applying to these selective universities. How big a deal is it? And when the Supreme Court gets involved in it, is it because it's an issue in general versus it's an issue of the very narrow selective colleges and universities?
So it probably all trickles down and has an impact in all different areas, because you have your highly selective schools where obviously it's an issue because everybody who applies is hoping to go, and there's a large number of applications for a very small number of enrolled students. So that's why you see these cases usually with a Harvard or those types of schools. I'll say Trinity College because I went there, but it's it's those schools where there's a large number of applications for each accepted student. But it also applies to all these state schools where there are big schools and people want to go there, and there are still a large number of applications. And so it applies really across the board to public schools and schools that accept public funds. And so it is an important issue. And that's why these cases end up in the Supreme Court.
And yet we still read that on a state-by-state basis, there are at least 10 states that have passed laws either limiting or banning the use of affirmative action in their college admission processes. And so I guess there are some merits and advantages to all of these things, but when you see that there are 10, there are likely to be more. What do you say about the fact that there are, at the state-by-state level, people taking a stand to put a cap on some of this affirmative action?
So there have been some cases that said that that is constitutional. I don't know if there's been a direct challenge yet where there is a student who is otherwise being affected that's brought it and said, because of this state's ban on affirmative action policy at a state university, say, I was discriminated against, or I couldn't get in, or I should have been helped and I wasn't, and therefore, under the equal protection of the 14th Amendment, I want to bring my case and have it heard. So I still say that although I think it's pretty much been affirmed, that that's still a possible challenge to that. And also, we should point out in the Harvard case, the Department of Justice has actually weighed in and taking the Trump position that we don't like affirmative action. They're trying to use that case to say affirmative action shouldn't be the norm anymore. So obviously, if the Supreme Court took this case as it came up and said, yeah, we are now backing off on our previous rulings, our precedent on affirmative action because of a change in the need for it in society, that would just take away the need for each state to do it state by state. But I don't think society is quite there yet.
So the other issue about that, and I guess it sort of ties into this, is the idea that who would ever say that there hadn't been discrimination? Very few. Now that you're getting closer to maybe a little more balancing, maybe we haven't completely arrived, but we're on our way. Has affirmative action outlived its usefulness? Even in a lesser case, I remember when we would hear years ago about Title IX, give girls a chance, they can do well, et cetera, et cetera. And now that's probably a little less of a hotbed issue. So has affirmative action, such as it is, outlived its usefulness?
Well, that's what the court was saying in one of its cases,
yes,
where it said, we're not there yet, but we may get there someday. And so that's what the Department of Justice weighing in is hoping that this Harvard case could come up and be the one that says that.
From a legal perspective, in the past few presidents we've had, now Trump, previously Obama, and previously Bush, there are notes that are written about Bush having written a friend to the court brief, another one that was called another kind of document that was non-binding for whatever. What is its value and why does this matter? We know that Trump is about to get involved with what will be the next Supreme Court justice, but when they talk about friends of the court brief, what standing does that have? Yeah,
so that's what I was referring to. They, in Latin, call them an amicus brief. And so interested parties are sometimes invited by the court to weigh in on an issue. And so the process of how an appellate decision is made, or in the Harvard case, it might be still at the lower court, but they want people to weigh in on what they think the law is for the court. The court will invite interested parties to write a brief, just like the parties will write a brief. So in a case in the Supreme Court, the appellant will write a brief on why the court should hear the case and why it should be decided in their favor. The appellee will write a brief and say why the law is in their favor and the case should be decided in their favor. And then, in many instances, there are other groups that would have an interest in the issue that aren't parties to the case. And the court will invite them to write briefs to weigh in, but that's as far as their involvement in the case will usually be.
So that other word was called a guidance document. Guidance doesn't hold water, I guess, as the ACLU had said, this is really going to be, we'd like you to consider this, but it's really going to the Supreme Court. And I guess Jeff Sessions was one of the folks who had responded to this issue, and now, of course, it's going to be challenged and played out in the Supreme Court. Another issue about affirmative action and whose ox is gored, apparently as this affirmative action and who's being accepted into some of the elite colleges, there's an issue that is very unpopular, that is the legacy student. So if affirmative action, how it changes and how it will impact on whether or not your child and his child, all who went to that particular college, gets the edge regardless of their GPA or whatever. How does that stand?
So if I'm following you correctly, affirmative action cases might say that you can't give an advantage to a legacy student because it would be at the expense of somebody
else.
Whose rights are being violated under the 14th Amendment. And if you did away with affirmative action, legacy students would now have a greater advantage?
They could, or how about if you get rid of it entirely, that means the sons or the daughters of the alum, or if they were donors, suddenly end up not only making the Z list for on the president of the college's notebook, they may not at all ever get involved in being part of that college or institution because they clearly didn't have the grades. And of course, Jared Kushner was one who was considered to be a legacy kid. Whether he got in on merit, probably not, as they said, but because he was related to, he ended up getting into an elite college.
I don't know enough about the admissions process for legacy students and all of that to really weigh in, other than to say that for a private school, they can have a lot of different rules than a public school can. So I'm not sure, like the University of Rhode Island, how much credence goes to a legacy person, or the University of Michigan, as we would have used in the example of some of the cases that already came through. But to the extent that you're trying to enroll a class that has a lot of different components to it, it would seem that that's potentially one of the areas that they could weigh in on and say it's okay, but again, maybe not if it's at the expense of other people who would otherwise be qualified to get in.
It certainly makes sense that at times you might want to have generations of families who've been at this particular college or institution, even if it weren't an elite college. But at this point, or the expense of others who really should have had a seat when your child shouldn't have, there's a reason to quibble about it.
I'm going to say that's a question better answered by a university president.
And some of them do weigh in. So back on the thought of why there should be affirmative action, diversity has become such a hotbed issue. Is there any reason that colleges shouldn't want to balance their student body? It brings new people, new ideas, new perspectives to the table.
That's always been the underlying theory as to why it's constitutional. And I think that that's a theory that still holds water. I think it's a valid educational agenda to have, so that when you have your class and you have these kids learning not only from the professors but from each other, there's as much perspective on an issue as you could possibly have. So that is a totally, in my opinion, viable argument for both either continuing what's currently in place or having a process in place that creates as diverse a class as you can enroll.
And I think it's worth mentioning that while we started by talking about white, black, Asian, and now perhaps legacy students, this also pertains to those who are white but perhaps economically disadvantaged or just in some other way culturally disadvantaged. Bringing them to the table or bringing them to the institution certainly has its own enriching value as well.
Diversity has always been looked at more than racial, Hispanic, black, white, Asian, whatever. It's socioeconomic too. And those, again, are different perspectives of people when you have them in a classroom to have a discussion on different things. So it's a much broader view of the word diversity than just looking at that one aspect of it.
And yet it's curious to say, along with the diversity, they talk about even sexual orientation, the LGBT group. If we look at them as being largely underrepresented as a minority and we want to bring that level up a little bit, then the downside of it, they said many college applicants who would otherwise not qualify will then pretend to say they're gay. I imagine with every policy that you could possibly have, someone might want to game that system, but that seems like such a stretch to do that, but yet these things are coming to the fore while it's being bandied about.
Again, that's another group that you're mentioning that it certainly falls under the diversity umbrella, and again brings just another perspective to those discussions and those classrooms, and the reason why admissions is such an interesting but difficult art for these schools to apply to their applicant pool.
But isn't it true that almost all colleges have that qualitative portion, the essay portion that lets you build a case for whatever your case is, which seems to be the real reason they wanted to have a leveling field. Tell us something about you that isn't reflected in the cold light of day in those numbers.
Yeah, the essay can be used for a number of different things, but certainly to get a better perspective into each applicant, number one. To also see how well that person writes, which is another component of who you want to accept. But it's certainly important to get, for both the college applicant writing it, to know that this is a chance for the college to see you as a person, so that they have a better idea of who you are and why they should accept you, as opposed to the other person whose application they're reading next.
So, you know, as you talk about that, you're talking about a whole person and a larger perspective, and presumably that's what the Supreme Court wants to do too, look at the bigger perspective of all of this. Well, we hope that this has been helpful to you and your little ones who are looking at college admissions. Stay tuned to the affirmative action issues. It's still a hotbed, still to be decided, and still a little bit political. Stay tuned to The Law Matters, because it matters to you.